Welcome to our explainer. Today we are going to tackle something that can feel super sudden, really confusing, and honestly incredibly frustrating for a lot of people: how a cell tower actually gets approved in your Connecticut town. We're going to break down the rules of the game so you know exactly how to make sure your voice is heard. You know how it goes. It might start as a rumor, or maybe you see some survey stakes pop up in a field down the road. All of a sudden, there's talk about a huge cell tower going up near your home, and your first thought is probably, wait, can they even do that? Who do I talk to about this? It's so easy to feel like you have absolutely no say in what's happening. And trust me, that feeling is super common. This quote just nails it, right? People often find out when it feels like the deal is already done, and that feeling of being too late is exactly what we need to get ahead of. The good news is, you might not be too late if you understand how the real process works. So let's get to the big question. Who is actually in charge here? It's totally natural to think it's your local planning and zoning board. You figure you go to town hall, you make your case, and the town decides. Simple enough, right? Well, when it comes to most cell towers in Connecticut, that's not how it works at all. This right here is probably the single most important thing you need to know. For most of these big telecom projects, your local town boards, they don't have the final say. The real decision gets made at the state level, and that's why showing up at that town meeting might not have the impact you were hoping for. The real decision maker is this group, the Connecticut Siting Council, or as you'll see it, the CSC. It's a state agency that was created specifically to handle the placement of big infrastructure like energy and telecom facilities. For these applications, they are basically the judge and the jury. Now, the Siting Council doesn't just get to do whatever it wants. It has to follow a very specific state law, the UAPA. And this law creates a strict, legally binding process for everything, from public notices and hearings to what counts as evidence and how you can appeal a decision. You can think of it as the official rule book, and knowing the rules is how you can actually play the game effectively. So, why does it always feel like these things just come out of nowhere? Well, it's because the public timeline starts with a bang, like a shotgun going off, but it's long after all the private work has already been done. And this really shows you the imbalance at the heart of the process. A cell phone company will spend months, sometimes even a year or more, looking for sites, doing studies, negotiating with landowners, all of it happening behind closed doors. The public clock, that's your clock, only starts ticking on what we call day zero. And that's the moment they officially file their application with the Siting Council. So here's what that official process looks like. After day zero, your town officials might get a heads up within a week or two. But look at this. The really critical events, like the site visit and the public hearing, can happen in as little as a month. That gives you a very, very short window to get organized before the council hands down its final decision. Okay, so given this super fast timeline and the fact that a state agency is in charge, how can a regular person or even a whole town actually have any real influence? Well, there is a key. There's a specific tool designed for exactly this purpose that most people don't even know exists. And let me be clear, just showing up is important. Sending an email with your concerns or speaking for your 3 minutes at the public hearing, that's good. Your voice absolutely should be heard. But it is not the most powerful way you can participate, not by a long shot. If you really want to influence the outcome and protect your rights, there is a formal status you can request that completely changes your role in this whole proceeding. This tool is called Intervenor status, and what it does is legally elevate you from just being a spectator in the audience to being a formal participant in the case. You're no longer just a commentator on the sidelines. You become a party to the proceeding with actual rights and responsibilities. It's a game changer. And the difference in power is just huge. Look at this. A commenter can speak. An intervenor can submit formal evidence. A commenter states an opinion. An intervenor gets to submit written questions that the applicant is legally required to answer. And maybe most important of all, only an intervenor helps build the official record and preserves your right to appeal a bad decision in court later on. So who can do this? You might be thinking you need to be some high-powered lawyer or a technical expert, but you don't. Your town can intervene. You, as a resident, and you don't even have to live right next door, can intervene. And this is critical. Under Connecticut's Environmental Protection Act, literally any person can intervene based on environmental concerns, and you don't need a lawyer to do it. Okay, I've mentioned the record a couple of times. I know it sounds like legal jargon, but I promise you this is the single most important concept in this entire process. Understanding this is the key to understanding why being an intervener matters so much. This quote says it all. You can have the most brilliant argument in the world, the most stunning photos of a beautiful natural area, or an opinion from a world-renowned expert, but if you don't get it submitted into the official administrative record for the case, then as far as the law is concerned, it simply does not exist. See, the Siting Council can't just make its decision based on a gut feeling or what they think is right. Their final decision must be legally justified by what's in that record. So if the only real evidence in the record is the stuff the applicant submitted, it becomes incredibly difficult for the council to say no. And this is how you shape that record. As an intervener, you get to formally ask the tough questions. In legal terms, they're called interrogatories. You can demand hard data on their coverage maps, you can question why they didn't choose other, less disruptive sites, and you can challenge whether this tower is even necessary in the first place. And guess what? Their answers become part of that official record. And here is the long-term payoff. Building that record isn't just about trying to convince the council right now, it's about laying the groundwork for a potential appeal down the road. If the council approves the tower and you believe they made a huge legal mistake, you can only challenge them in court based on the evidence you already put in the record. No record, no appeal. Okay, I know this is a ton of information, but if you hear a tower is being proposed in your area, it all boils down to a few immediate, absolutely critical actions. Let's walk through your action plan right now. First things first, go to the Siting Council website and find the docket. That's the official public file for the application in your town. Second, go ahead and submit your initial comments right away. Third, and this is the big one, file the simple paperwork to formally request intervenor status before the deadline. Then, use that status to ask those tough written questions. And finally, put every single deadline on your calendar because they are not flexible. It all just comes back to this, doesn't it? The process can feel like it was designed to shut people out, but it's really a legal system with a very specific set of rules. And once you understand those rules, you completely transform from a passive, frustrated observer into an active participant. It really is the difference between frustration and empowerment. So, in the end, the process isn't some locked door you can't get through. The law itself actually gives you the keys: public notice, hearings, and most importantly, intervenor status. So the real question isn't whether you can have a say, it's whether you're prepared to pick up the tools the law gives you and put them to use.